I started the show with two people who know a great deal about the Constitution, Judge Michael Luttig and Lawrence Tribe. I'm now joined by two more of the best people with whom to have a conversation about the Constitution. Akhil Amar is a Sterling professor of law and political science at Yale University. He's the host of the podcast America's Constitution and the author of the book The Words That Made Us, America's Constitutional Conversation. Also joining us is Jeffrey Rosen, president and CEO of the National Constitution Center, America's leading platform for constitutional education and debate. These two guys are not just friends, but people I turn to for some real guidance on the Constitution. And you are probably the two guys, if we're going to do a literary conversation about the Constitution, to have here, because you both love it so. Professor Amar, let me start with you. This wasn't part of the plan when we asked you two to be here, but at the beginning of the show, I spoke with Lawrence Tribe and the former federal judge Michael Luttig, and we discussed the way in which the 14th Amendment of the Constitution directly affects Donald Trump and why the Constitution may allow for accountability for Donald Trump. I want to just first read what Section 3 of Amendment 14 says. It says, "No person shall be a senator or representative in Congress or elector of vice president and vice president or hold any office, civil or military, under the United States or under any state who, having previously taken an oath as a member of Congress or as an officer of the United States or as a member of any state legislature or as an executive or judicial officer of any state to support the Constitution of the United States, shall have engaged in insurrection or rebellion against the same or given aid or comfort to the enemies thereof. But Congress may, by a vote of 2/3 of each House, remove such disability." Here's what Lawrence Tribe had to say about that.
The Constitution says a lot of things, but it takes people to honor it and to enforce it. Now, some people have made the mistake of thinking that the many charges against the current president represent the forum in which all of this will be decided. The 91 pending criminal charges in 4 separate indictments. But in fact, although those criminal prosecutions are terribly important, and it's vital that the president be held accountable and not get away scot-free, the disqualification clause operates all by itself.
Now, Akhil, if I can just ask you to put aside your animosity for a moment about the fact that Lawrence Tribe is at Harvard and you are a Yale constitutional professor, I wouldn't mind your take on what Professor Tribe says about the disqualification clause.
He's a dear friend. We've co-authored things together. Larry, that was great. You're absolutely right that it's self-executing, meaning we all have to take it seriously. And Ali, I love the fact that you, as a naturalized American citizen, probably 20 times, and just today, you've held up this document, different versions of it. Jeff, sorry, I don't have my National Constitution Center version because it's all beat up and worn out. But yes, you're right. We all have to read it. We have to take it seriously. Lawrence Tribe is, eminent, and he's taking a strong position on one side. He's one of the two most cited emeritus scholars cited by the Supreme Court alive today. Will Bode, my former assistant, has taken the same position. He's one of the two youngest scholars cited by the Supreme Court. On the other side is the great Michael McConnell, who's one of the two most cited active scholars by the Supreme Court, former distinguished judge. I'm actually on that list too. And they disagree. Bode clerked for McConnell. Michael Paulson worked with McConnell. So constitutional scholars actually disagree about this. In fact, since you mentioned podcasts, I'm going to have Bode and Paulson was my law school roommate, on America's Constitution podcast next week. And I'll give them hard arguments on one side, and they'll, give their counter arguments, and we'll let American voters, the American citizens, decide. And that's in the tradition of Jeff Rosen, who always at the National Constitution Center brings, the best people on both sides and have them make their arguments.
And Jeff always says that. Even when we discuss a decision, Jeff, you always say, read the dissent. The very few things come out of the Supreme Court where they are professional interpreters of the Constitution that are unanimous. So I want to go back to what I thought I would start this conversation with, Jeff, the Second Amendment, which is probably one of the most disagreed upon amendments in the Constitution. You've joined me on this show to discuss this before. Talk to me about the dueling interpretations of something that, to some of us, when we read it, it seems obvious. This was about militias in 1791. Very different story in 2023, where we don't actually have militias in the United States, and maybe everybody shouldn't have a gun. Tell me about why this one is so stubborn and difficult.
Well, the best place to begin is at the National Constitution Center's interactive constitution, where we have leading liberal and conservative scholars disagreeing about the meaning of the amendment. But broadly, the two interpretations are the one that focuses on the first words, which say a well-regulated militia being necessary for the security of a free state, and say that really the purpose is to protect the right of people to mobilize themselves in a militia, and originally to prevent the federal government from taking away people's liberties and empower people to defend themselves by arms. That's the collective rights interpretation. And then the individual rights interpretation, which stresses the second part of that clause, the right to bear arms shall not be infringed. In practice, though, thanks in part to the scholarship of my dear friend and teacher, Akhil Amar, and it's so wonderful to be in conversation with him, and Professor Tribe, there's a pretty broad consensus that by the time of Reconstruction, the amendment was intended to protect an individual right to bear arms, in particular of African Americans, to defend themselves against mob violence before and after the Civil War. The big debate in the country today is stemming from the Supreme Court's landmark decision recently in the Bruin case, which said essentially that any regulation of the right to bear arms has to have a precedent in text, history, and tradition. And that's a new test that's really thrown lower courts into chaos, because it's forcing them to search back to the Statute of Northumberland in 1392 to ask whether or not domestic violence orders, for example, may be constitutional, which is the big case the court's going to take up next term in the Raheny case. So essentially, although there's agreement about the individual rights core of the amendment, there's disagreement about the application of this new history and tradition test. Lower court judges are all over the place about how to think about weapons that the founders couldn't have anticipated, like assault weapons and AK-47s. And the Supreme Court is really going to have to sort this out, because if they don't, a lot of gun regulations may be open to question.
Akhil, most of us are, whether we agree or disagree on various clauses in the Constitution, are not prepared to throw it out, with the exception of Donald Trump that time that he said so. In 2020, Jeff wrote an article for The Atlantic called "What If We Wrote the Constitution Today?" So I want to ask you, because I know you two talk a lot, I want to ask you, Akhil, what would a modern Constitution look like, and how would you even arrive at that process?
So I love the fact that you've talked about not just the original Constitution amendments. We're talking about the 14th Amendment. You mentioned the 19th Amendment. Constitution, even if you believe in reading its words and you don't think judges should evolve it, the people can. It's called amendments. But I want to remind everyone there are also 50 state constitutions. So we don't have to just speculate as to what people might do today, because they actually do amend their state constitutions all the time. State constitutions are easier to amend than the federal. Since Jeff has over his shoulder, actually, his hero, Louis Brandeis. Louis Brandeis says, let's take a look at state experimentation, state laboratories. And one of the best arguments for a gun right, I don't own a gun, but, one of the best arguments is individual right to have a gun for self-protection is in most modern state constitutions. And in fact, in the Bruin case, there's a concurrence by Justice Kavanaugh, joined by the chief, saying, let's look at actually other states. New York, in that case, was really an outlier. And that would be an alternative test to the Statute of Northumberland. Let's look at how Americans today, state by state by state, think about gun rights. And that's a very Brandeisian idea. States as laboratories, it's a modern modern idea. It's a synthesis of written constitutionalism and living constitutionalism.
The only failure of booking the two of you to talk about this is that this isn't a segment. This should be an entire show, and we're going to start working on that because there's so much to discuss. I'm so grateful to both of you. Akhil Amar is a Sterling Professor of Law and Political Science at Yale University, host of the America's Constitution podcast, to which you should subscribe, and author